Good afternoon. My name is Paul Millenbach from the Foster Swiss firm. And today is our second Wednesday series. And today with me is Cliff Hammond from the firm. Cliff is a shareholder in the employment services practice group of the law firm. He works in the offices in Southfield and Lansing. I think, Cliff, you kind of bounce back between the two, correct?
Correct. Yep. I'm in both.
Great. Cliff is very well versed in employment law. And this is an area of law that's something that he's been heavily involved in his entire career before and with Foster Swift. So thank you for attending, Cliff. And today we were going to talk about the price of misclassification of employees. And could you just give kind of a broad review or a broad summary of what you intend to talk about today?
Yeah, I think we're going to talk a little bit about, who's your boss? Really, that's what the question is in these kind of cases. Are you your own boss? Are you an independent contractor that the person you work for doesn't pay unemployment, doesn't do workers' comp, or in some cases may, but you're not having that person do anything more than give you a check for services provided, versus whether or not you're supposed to have a boss, and whether that person is supposed to take taxes out of your paycheck, whether or not that person is supposed to take care of you as far as your benefits, overtime, all the different rules and laws that apply to employees that don't necessarily apply to somebody coming off the street. And it's a very technical, very individually based, and frankly, a wild west of what the rules are, because they keep changing all the time, issue. And so what we talk about is, should an employer take a person and pay them with a 1099 and just give them money, or should they make them an employee? And it doesn't really matter sometimes on the things that you've heard, such as, well, everybody does it, right? Everybody does it in the industry, or, oh, this is what happens all the time. It's a legal issue. And so we'll talk a little bit about, and we could talk all day about every individual issue, but we'll talk about who is and who is not, under the law, your employee. And we'll talk a little bit about how it may be confusing, and it also may be surprising to some people what some of the rules are on this.
Thank you, Cliff. And so essentially, we're talking about the difference between an independent contractor and an employee, correct?
That's correct, right?
And that's something that's obviously, there's been a lot of, my understanding in that area, there's been a lot of changes in the law. There's been IRS regulations. There's been regulations, cases, and I've all kind of interpreted that to be a little bit different. And we'll dig into that a little bit. But can we first discuss what does it mean to misclassify an employee? What if you misclassify someone from as an independent contractor instead of an employee?
Yeah, it's a good question. And it's one of those ones we can go on for a long time. So let's talk a little bit about it from a 30,000-foot view. If I'm an employee for purposes of wages, okay, that's generally under what they call the Fair Labor Standards Act. And then Michigan's got a law called IWOW, the Improved Workforce Opportunity, Workforce Act. And those are the statutes that say, pay your employees minimum wage. And then if they work over so many hours, depending on where you're at, what industry, mostly over 40, could be 8 and 80 in some industries. And there's other requirements for different people. You've got to pay them overtime, or at least pay them pursuant to some rules. So the Department of Labor, which is the federal agency, they look at it and they have tests. They have tests about what's the economic reality of your relationship, right? Are you actually an employee, or are you actually somebody off the street? And I'll give you an example. So here at the law firm, if we hire somebody that comes in and cuts the grass around the building, now you would normally think that person, if they own their own lawnmower and they own their own, Cliff's Lawnmower Company, and I pay them X dollars to cut the grass, that would be an independent contractor, right? That's kind of what we think about. Now, that test would be, and we'll talk about it in a minute, that test is what the Department of Labor has come up with based on the law. But every agency is a little bit different, just to make it spicier, right? So now the IRS has their own rule. And they've actually got sort of a 3-factor test that they use: behavioral, the way you pay people, and the relationship that you have. And then you have unemployment. They've got their own test, and they use what's called the IRS 20-factor test, which a lot of people talk to me about, except the IRS doesn't use it. It's funny that people think the IRS 20-factor test is what you're supposed to use, but it's actually not what the IRS uses. They use a different test, but Michigan's unemployment office uses that 20-factor test. So depending on where you go and what situation you're in, you may have a little different outcome on each one of them. But we'll talk about what we're talking about here, which is the wage issue first. Now, really what courts have looked at for years is the economic reality test. So courts look at it and they say, okay, what are the services that you're providing? Are they integral? Are they something important to the company, right? So is it something that you do? What's the skill that you need? Okay, what's the skill required? What kind of training? What kind of experience? What's the worker investment in the equipment and materials? Are they buying their own equipment? Are they bringing their own van? Are you supplying it, right? What's the permanency? Now, how long are you going to work? Is it going to be like, hey, this is a project base? Or is this going to be, hey, just keep working as a contractor forever, right? Is the person going to make a profit or a loss based on their industriousness? In other words, is there an opportunity for the person to come in and make a pretty good profit if they know what they're doing and do a good job? Or is it just, here's how much money I'm going to give you, and there's no real opportunity to make more or less or to lose your shirt? I mean, is there something in it for you as an independent business person? And who controls what you do? Because the ultimate question is economic dependence. And that's what they always look at in the courts. They look at it and they look at all these factors and they say, look, if you're more likely or not somebody who 100% relies on this company for all your work and you don't hold yourself out for business and you've been there for 20 years and you're not going anywhere and you use that company's tools, but you've got a nice skill. Well, they look at all the factors, none of them being more important than the other. And they say, okay, more likely or not, are you really economically dependent? Now, that's what courts have historically done, but they've kind of shifted here, there, and everywhere, like all the courts do over time. And the agencies come up with these rules we talked about. And the Department of Labor has kind of said, we're going to develop some rules to help employers understand it. Now, those rules that I just talked about are kind of the traditional tests that you'll see a lot of times. But under the Trump administration's first session, and when he was in there the first time, he said in his Department of Labor, he said, let's go back to just two different rules. Because I'm looking at all these court cases, according to the Department of Labor, and there's really two things that courts really drill down on, what you need to understand. One, who controls the work? Who's telling you what to do? The more the employer tells you what to do, the more likely you're an employee. And the less likely for you to be an employee if they say, look, come in here and do whatever it is that you do, right? So that makes sense. If you're truly an independent contractor, I'm getting you for your services and their skills. I'm not telling you how to do your job. I'm telling you what the job is. And you can have a limited amount of control, but only so much as the law requires or is required to dictate what you want from that person. Okay, so if you give them a handbook, you're controlling them. If you're telling them when to come in, how to come in, when to take a break, how to take a break, how to do your job, then you're going to be less likely to be an independent contractor. The other thing they looked at was, all right, can you get that profit or loss, right? We talked about profit and loss is a big deal. So are you really a business person or are you just getting paid? Are you a worker bee or are you actually somebody who's hustling? Now, that rule was actually passed, put through a process, and was going to go into effect. And then the election happened, and Trump moves out of the White House. Biden moves in. His Department of Labor people said, not so fast. We don't like that. We're going to get our own rule. So they suspend that rule, put another rule into effect last year. And now this rule really changed things. It basically said the same thing we just talked about, the courts look at, right? It had 6 factors. They're looking at how much you're investing, things, but they really started to drill down. And they said, listen, I'm not asking you if you invest in your company, for instance. I'm asking you, are you investing the same amount kind of correspondingly as the employer invests in its enterprise? And then the question is, what's the nature and degree of control? Not what you actually control, but in your agreement. Did you say that you could tell an independent contractor to fire one of their people? Not that you did or didn't do it, but does your contract say you have a lot of control that you could exercise? And the opportunity for profit and loss was really scrutinized. And then not only was it, look, again, we talked about the person with a lawnmower who's cutting the grass for the firm, but let's just say I call you in and I say, listen, I need some help with IT. You're a very skilled person. You come in, you do IT work, you come in and you do a project for me. Now, obviously, I'm just getting you for a short-term basis. You're a skilled person. You're coming in, you have your own company. But the question under the new rules that were passed last year was not whether or not you're integral to my legal services, but what you're doing for me, is it important? Is it important? And if the answer is yeah, it's important, which I'd say IT is for a law firm or whatever company you're working for, probably, then that might actually tip in your favor. Now, what the rule said was none of those factors is more important than the other. There are no two more important, like the Trump administration had said originally. It's all these things are looked at, and they're trying to get to, are you more likely or not an employee? Yes or no? Are you dependent on them? And they really tighten the screws a lot on saying, if you require somebody to do more than what the law requires, you're more likely to be an employee. So in other words, if you have more requirements on the way people dress, or we've talked about this before, Paul, if you're a truck driver and you are an independent contractor, owner, operator, and you can turn down loads and say yes or no whenever you want, that's one thing. But if you can turn down a load and that might go against you the next time I'm opening up a lane or an opportunity to do work, if that's going to go against me, then you don't have discretion. You don't have individual ability to do your job. It also goes to the factors of looking at what the person's doing for you, how they're doing it, how much they're doing it. So if you have a non-compete agreement with an independent contractor, you're most likely not going to be an independent contractor because I'm restricting you. I'm telling you what you can and can't do, both with me and without me. How many people are you working with? So we're looking at the permanence, we're looking at the integral part of the business, and we're looking at initiative, we're looking at your skill. And even if you're just skilled, the question or these rules was more than that. That's just one factor, but what type of skill? How much work did you, how much is it? Are you really skilled for the job, or are you just skilled in general? So you could have all the greatest degrees and certifications in the world, but if I'm only offering you an opportunity to work doing a finite task, then that's not going to bode in an independent contractor favor. So this really made it difficult for most employers, frankly, to find somebody who would be an independent contractor. It really made most independent contractors misclassified. In other words, you had to really look at your contract, look at the things you're asking for, and make sure those individuals you're contracting with are at an arm's length. They're not dependent. In other words, they're not 100% dependent upon you, and that they're investing in their company and you're not providing them tools. So if you just needed somebody to come down and help you out in the summertime, and you're like, well, it's just a short-term deal, that's most likely going to be an employee relationship. So that's where we stand with this rule. It's very tight, it's very tough, and it's reality. It's the rule that's been promulgated by the Department of Labor. Well, the Trump administration just announces, hey, you know what? We don't like that rule. That rule's a little tough. We think there's a lot of people out there that are doing things that have been in business for a long time, and this would disturb that model. Let's not enforce that. They didn't get rid of the rule because you have to go through a big process to get rid of the rule. They're just not going to enforce it. It's like, yeah, it doesn't exist. Now, that's a big deal because now what do we have? Well, now we go back basically to what I told you was the economic reality test. But what they've said is that, look, there's important factors you got to understand. Where the work is performed is not important under what the Trump administration's Department of Labor is saying. So it doesn't matter where you're doing the work. The absence of a formal agreement, like an actual written agreement, isn't necessarily required, okay? And whether you're licensed, in other words, whether you have an LLC or an incorporated status, isn't going to necessarily, under the way that the Department of Labor is going to enforce this, but anything. So you can have handshake deals. You can have, hey, come on in here and I want you to do the work at my shop, my office, or I want you to do it at your shop, your office. That could be a factor. However, that only applies to Department of Labor investigations. If I sue you, because I can sue you, I can either go to DOL for an investigation or I can sue you in court. If I sue you in court, then you're still going to have this Biden era rule in full force and effect that you've got to go by. And by the way, the unemployment office uses the 20-factor test, and the 20-factor test says, look at all the factors you do, and it's very similar to the one that the Biden administration did. So you could have a person that the Department of Labor says, definitely independent contractor, no problem. We looked at it, you're good. But the unemployment office says, no, you have an independent contractor that you misclassified, should have been an employee, and you should have paid all the the back pay and all the contributions on their behalf, and they're entitled to unemployment. And then the IRS could come in with their rule, and they could say, well, yeah, I think they are an independent contractor, or they're an employee, because each agency has its own individual rule. So where we stand today is pretty much where we've been over the years. It's a sliding scale, but it's even worse, because if a federal agency comes in, they're letting you have a little more leeway. You better hope the government comes in. This is the first time ever that people were hoping that the government comes in and does the investigation. Because if they sue you, you're going to have a harder time proving that your independent contractor is an employee.
Who triggers those investigations? Would that be, in your experience, is it an employee or an independent contractor that would contact the government and ask them to investigate?
Yeah, usually the only way they're going to get into your building is if somebody who's mad or upset calls them up, right? They could call them up. That's the number one way, and it could be anonymous, or it could be a person doing it with their name on it to do an investigation. So I can file a claim with the Department of Labor, or I can go and file a lawsuit. So I could do it myself as an employee or independent contractor first. Sometimes whistleblower, you might call them, right? Somebody who's disgruntled in the office might say, well, they're doing this with all their independent contractors because I want to get you in trouble, right? So they could call up and do an informal investigation. And then there are times when the Department of Labor or the Michigan State Department of Labor can do an investigation. And they can do it because they're saying, we're going to go look at trucking. We're going to go look at hairdressers. We're going to go look at people who are working in automobile factories. They could take a sector of the economy and just target it for an investigation. So those are the three ways you really see it occur.
And what would they recover? Would there be would the employee or the independent contractor then recover damages, or would the state or the federal government impose a fine against the employer?
Well, that's a good question, and this is something that's changed. So under let's just talk about what does the Department of Labor do. So the Department of Labor enforces the Fair Labor Standards Act, okay? And so if they come in and find against you for forever and a day, it used to be they would make a workout with you. They would say, look, you owe Susie and Johnny, they should have been properly classified. If we look at this, we've noticed that you should have paid them some overtime. You owed them, $150 for the last 6 months, or $50,000, whatever the hours were they worked, whatever you misclassified them as. And they would make a deal with you. If you did that, they would let you go, right? They would just say, you sign this, we'll approve it, we'll let you go, everything's good. But then recently, I would say over the last 10 years, they've started saying, no, we're going to make you pay double damages. If you owe anything, it's doubled immediately, even if you settle it before it goes litigation, because the Department of Labor can bring a lawsuit on behalf of the employees as well. And they'll say, look, if you want us to settle it, pay us 100% times 2. Why in the world would I pay 100% times 2? Well, because if I go to court, I actually might have to pay more damages. I might have to pay a damage or a fine or a penalty for willfully doing this. And I might have to pay attorney's fees, even though the government doesn't really have an outside attorney. So there would be some, I would have to pay my attorney. I'd have to pay these damages and double time. Well, the Trump administration just came out recently in the last couple of days and said, look, here's the deal. When we're doing investigations, you just pay whatever we find. We don't have the authority to give liquidated damages in the investigation phase. Okay, so we won't do that. But remember, that's good news for everybody. So you want to settle it if you can. If you don't agree, you don't have to. You can always fight it, right? You can always say you're wrong. But if the person gets their own private attorney, because you can go either way, right? An individual or a class of people can get these people. And if you get a person that goes in the court, the damages get big. You bring the Brinks truck up, because it can get very expensive very quickly. And I'll tell you how. Let's just say you have 30 or 20 independent contractors. 15 minutes here and there can add up pretty quickly. 40 hours can add up really, really quickly, right, over time. And they go back 2 years for a normal case, 3 years if they say you did it intentionally by not classifying them properly. And they'll get all the overtime and unpaid wages times 2 plus attorney's fees. And if you go across the way, if you have just one person, you can run up $100,000 easily in attorney's fees that you have to pay on top of the interest, the double damages, and any fees and costs that they find. And if they do a class action for those 20 people, now all of a sudden the attorney's fees goes way up, and the number of people that might be hit goes way up. So your number and your multiplier goes up real quick. And if you look back, even if you only have, let's say, 10 employees, well, you have more than 10 employees over the course of 2 years. So the class can get bigger, the damages can get major. Now, what else can happen to you? Well, there's a lot of things that can happen to you. Number one, you could have the IRS say, well, wait a minute, you weren't paying taxes all this time. So not only are you misclassifying, you didn't pay taxes, you owe us money back, and we're going to hit you with a penalty. And then you could have an unemployment workers' comp claim saying you should have been paying for all these people, so we're going to get you a penalty. We're going to have you pay all these things back. You could have an issue with ERISA. Maybe you had a pension plan. Maybe you had a 401k plan. You weren't properly contributing. So the person brings a claim based on that. So there are a number of avenues just for the wage and hour issue that can expand. And our friends at the Attorney General's office have a special group that was created just before COVID outbreak that was looking at wage theft. And one thing that wage theft in their mind could be is you're not paying people properly because you're misclassifying them, you're not contributing taxes, and they could potentially come after you for criminal behavior. So lots of fine stuff if you misclassify people. It's very important. That's why it's really good that they don't know what they're doing with these standards all the time. Well, you have literally 2 standards at the same time for the same agency, plus every agency with their own individual standards. So as you can see, it can get messy, but honestly, there are common denominators we can look at.
Well, I guess we're running a little bit out of time. How do you prevent that? I guess what's the best piece of advice you can give in a couple of minutes to prevent these type of investigation or complaints or this quote unquote misclassification?
Well, the first thing you got to do is you got to audit. Everybody who works for you that doesn't get paid as an employee, everybody you're paying, you got to audit it. You got to audit it regularly. And you got to find out what's the contract, whether it's written or not written, what's the contract? Do they have independent discretion and control over their duties? And how am I paying them? What's the time of paying them? What is the basis of paying them? When we look at that and we look at these factors, like I talked about, the economic reality test factors, if we go through that and we regularly audit the permanency of the relationship, the investment in the equipment, the skill, the integration of the services as an important part of our business, how the work is performed, the opportunity for profit and loss, those types of issues, when we look at those and we stop saying it's okay because we've been doing it forever, because that's not a good enough excuse, right? That's not good enough. We have to look at the actual relationship and has it changed since we got in business with this group, right? And that's the key. So you have to know how many people you are actually paying. Then we got to look at the relationship, and then we got to look at the relationship through how it's working today, not how it was supposed to work. And my advice always is the best case scenario for you is to make sure you don't make a mistake by just pretending like it's okay and actually look at it. You can always alter your relationship moving forward to make it. And that's one of the things I always suggest. If you're not going to change it to an employment relationship, then you need to change it to be safer. But you're never safe from a person making a claim. So the way that you have to stop the potential harm is to constantly reevaluate your relationship, your contracts, and how they're being treated. And that's what you do. And I would say, we work with you. We have a number of attorneys here in the firm. We do this all the time. And Paul, you've had people that have had problems with this. I have this come up all the time, misclassification. We got to look at the contract. And the number one thing you got to remember is you can't agree as a person to be an independent contractor. It doesn't matter if I want to be an independent contractor. It doesn't matter if you want to be an independent contractor. So just because you put something in there saying, I agree, I am, it doesn't fix the problem. It's a no-fault situation. You're either wrong or you're right. So that's why I say we got to keep up on these different rules. We got to try to make sure we have the best contract possible, evaluate, and individually, because you could have 3 people doing the same thing, but they're not actually doing the same thing, right? They're treated a bit different. Some could be possibly employees, some could be independent contractors. And then there's a number of ways we could try to mitigate the damages going forward. But we don't have time to get into all of those because there's a lot of sophisticated ways to get out of that.
No, I understand. But the contract itself, contract is something that, and I've done many of them in the past, the independent contractor agreements, that alone won't protect you though. I mean, you would have great language in the contract and that says the person or the organization's an independent contractor. I use it in the trucking industry, but that the contract itself, the language of the contract won't protect you. You actually have to have more to it than that in terms of your actions, correct?
Right. It's a belt, but we need suspenders, right? We need both. We need a good contract. A bad contract sinks you, right? A bad contract will get you in trouble quickly. A good contract is a good defense, but it's not the only defense, and it's not going to be the fail-safe. So that's where I think a lot of people, you have to start with a good contract, period. I never say don't worry about it, because you should, right? We do a good job with our contracts for a reason, because they help us, but it has to be real. The contract actually has to be real, and it has to meet the legal threshold. And as you can tell, the legal threshold changes, so the contracts need to change. So what was okay 10 years ago is not necessarily okay today. And even if it says great language and has all the bells and whistles that we want, that doesn't mean that it's going to be perfect. That doesn't mean it's going to actually protect us against somebody who we're treating as an employee.
Let me give you just a quick example, and then we'll get to the couple of questions that are in the chat. But example, and I run into this a lot with the trucking industry, is that the contract, well, the trucking industry has to comply with US DOT regulations. And the US DOT regulations require the drivers to have a medical card and get a physical, hours of service, and those type of things. And that's spelled out in the contract itself. What does that do to change the dynamic of whether it's independent contractor or an employee? The fact that the employer has to make sure that all of its drivers, whether they're independent contractors or employees, have to comply with government standards.
Yeah, that's a great question, because that was actually addressed in the new rules, the 2024 Biden administration rules. They said, look, we don't have a problem with an independent contractor relationship where you require somebody to abide by whatever the Department of Transportation or any other federal or state rule requires. Where the 2024 rules get you in trouble is if you do more. So if the Department of Transportation says you have to have a CDL and you have to go through all this is the only way you can do it, that's fine. Nobody's going to have a problem with that, most likely, okay? I mean, there's always somebody who has a problem, but you're safe generally under that description. It's when you require them to do anything other than that for their testing. Right. So if you had drug testing that's above and beyond because you want to be a really safe place to work, well, that's where you're going to start running into a problem, because you're actually requiring and putting limitations on the person as if they're an employee. So
what
that's
about a uniform. I don't want to interrupt, but what if you require the driver to have a uniform that has their name on it or something like that? Is that above and beyond?
Yeah, historically, that's just a factor that probably wouldn't be a big deal. It'd be a deal, right? Because you're requiring a person to do it. But in this situation, it's going to lend itself to say, if you want somebody to wear your uniform, then you're putting a requirement on them that's not required by state or federal law. So that shows that they're more likely an employee. Now, there's a lot of factors. It's not the only thing, and that's the one good thing that we have. It's not like if you do one thing wrong, therefore you're not an independent contractor. But it's not going to bode well for you if you're doing that plus restricting their work. One of the things the 2024 rules did was you do something like that, that's okay, that's one factor. But let's just say you're in the trucking industry or in any industry, and they say, look, I'll pay you this much money for doing X. And you either take it or leave it. That's not really an arm's length transaction. You're not bargaining for the price. So when you don't bargain for whatever it is that you're doing, the service you're doing, that's another indication that, well, you're wearing their uniform, you're doing what they say at their rate. Now you're getting deeper and deeper. And then it's like, okay, well, can I say no to something? Can I work for somebody else? And if the answers are no, or they're limited in those areas, you become more and more likely to be an employee.
Yeah, let's get to the questions because we're already at 12:30. There's a few. First one is question, does it matter if the person has a separate full-time job and is doing only part-time work for you?
That's very helpful, right? So the facts are, the more open you are right? The more available that person is holding themselves out for business, other places, the better it is. It's not the end all be all because none of these factors are the only factor, but it's definitely good. But again, if they're, let's just say they're working someplace else and they take a side kind of independent contractor status for you. In general, you have a lot more freedom here, but if you start telling them what to do, where to do it, you start controlling the way that they act, and you do all the things that look like you're an independent contract, I'm sorry, an employee, then it doesn't matter, right? It's just that means that you got that factor in your favor, but the rest of the factors showed they were an employee because you can have a part-time employee, right? I mean, part-time employees work everywhere. So if you treat them like a part-time employee, then they're just going to be a part-time employee. Now, the good news, the saving grace is you may have to pay them overtime because they don't work that much. On the other hand, you still might not pay them minimum wage, based on the number of hours they're using to actually do the job. And the person can make it up. And if they sue you, they'll say, well, I know you say I work part-time, but actually I was at home and I was thinking about it and writing emails and just, drafting stuff up. I worked 100 hours a week. And the impetus is on you as the employer to keep records. And if you don't, then how are you going to refute their statements about how many hours they work? So again, the number of hours is good. The fact that they're working for somebody else is a great thing, but it doesn't end the investigation.
Okay. What is enforced by the Department of Labor focus of the Trump administration subject to deference in the courts, i.e., can the courts adhere to the law promulgated under the Biden administration since Trump has not rescinded those laws, just chose not to enforce them?
Good question. So we used to have what's called Chevron deference. There was a case called Chevron, and Paul, you know about this. For years, agencies were kind of deferred to. Whatever the agency said, they just did whatever the agency basically did, unless it was outrageous, right? There were times when they went way too far and went away from the statute, because that's what agencies do. The law is passed by our friends in Congress or in the state, legislature, and then they ship it off to some agency with a bunch of unnamed people that no one knows who they are, and they actually make a law. And they change the law, and that's the way it goes. And the courts were like, well, they're professionals. They know what they're doing. We'll just go ahead and do what they say. But they don't have to now, because that Chevron deference has been reduced. And now the courts have to do what they're supposed to do, which is interpret the law. So they could look at the 2024 and say, yeah, that looks like it's exactly what we're supposed to do under the Fair Labor Standards Act. And we're going to go ahead and do it. And we'll use that guidance from 2024. Or they might say, yeah, I'm looking at this guidance from them and that looks good, but I don't think that's actually interpreting the law. We're going to interpret the law and see whether or not you have an economic reality of whether you were or weren't misclassified. So there's an even more nuanced detail to the analysis that you're asking the question. Could the court ignore either or both? Yeah, they could. Now, okay, historically, the economic reality test is what the court's always looked at. So we're not that far away. It's just, are they going to be tighter on these factors like the 2024 rule or not? That question is still left to be decided. We don't know yet.
All right. The last question is, so aside from a good contract, we should take all the tests into consideration, including economic realities test, 20-factor test, et cetera.
Yeah, you have to take all the factors in there, but I will tell you that the best way to do this is to sit down and look at the duties of what the person's doing, the realities of what they're doing. I will look at the 20-factor test, but the 20-factor test, frankly, is a good test, but it's more of something for unemployment. What I would do is, if you really want to know worst case scenario, whether you could get hit, go to the Department of Labor's website, where you can talk to us, and look at the rule that was published in 2024. And they did a very good job. I don't necessarily agree with what they said on everything, but they did a very good job explaining what they're looking at. And you will see they have question and answer and examples of the type of things in different industries that would mean you are or are not an employee. And if you read that, I will tell you, some people are going to want to jump out the window because they're going to be shocked at how few people are going to be able to make it through that analysis. That's what I suggest. Worst case scenario. Until a judge comes out and rules one way or the other in the Sixth Circuit, whether or not they're going to go down this road or they're going to go down the Trump administration's new rule. And I'm almost positive, there's no guarantees in life. I'm almost positive Trump's going to put a rule out that will be published just before he leaves. And it'll be a little bit different and a little bit looser. So But if you want to right now know what your employees might do to you, go to the 2024 rule. That's going to be tighter than the 20-factor test.
Okay. Well, thank you very much, Cliff. That was very informative. As a parent, you know what you're talking about when it comes in this area. And we all appreciate your guidance here. If anybody has any questions and wants to follow up with Cliff, you can locate him through the website or give him a call. I'd be happy to talk to you about it. And our next Wednesday, second Wednesday session, we don't have a topic yet, but we'll be publishing it fairly soon, probably within the next week or so. And so look out for that. And then and hope you attend.